What happens if you're served with divorce papers and do nothing? I'm Jaclyn Robertson with JR Law Group, and welcome to Family Law Friday. Today we're going to talk about when you're served with divorce papers, what happens if you do absolutely nothing. It's important for you to understand that once you are served with divorce papers, and that means an independent, neutral third party has handed you divorce papers. This doesn't mean if your spouse says, here's a proposed divorce decree or here's a proposed settlement. That's not proper service and you can do nothing. But if you've actually been served by a third party, then the clock starts ticking. You have 21 days to respond to these papers. And if you do nothing, what will happen is by the time you're served with divorce papers, that means the petition for divorce has first been filed with the court, and then you've been served the proposed divorce petition. And if you do nothing, the other party has the option of pursuing a default divorce decree. And that means they can file papers with the court that will request a default judgment against you that will be consistent with exactly what is outlined in the petition for divorce that is served on you. So a lot of times a petition for divorce is what we call a wish list. When one party drafts their petition, this is what they think should happen in the outcome of the divorce. And so ultimately, if you don't respond timely, then ultimately the terms in this petition for divorce will be what defines the ultimate decree that's entered and will be what you will be forced to live by. Now, family law courts are courts of equity. It's going to be based on equitable principles. So if you've been sick or can really show that you had some solid grounds for not filing a timely response, then a court always has the discretion of finding that they're willing to give you an extension or to revert. But let me tell you, it's going to be a highly litigated issue. It's going to be expensive, and there's still no guarantee, especially the longer the delay there is in you responding. And if they pursue a default, get a decree, and time passes, it's going to be hard for you to step up and say, we need to undo this. Again, it could happen, and it has happened, and there's different reasons that the courts may consider your reasons for not responding. But save yourself the time, the stress, the money, and make sure that if you're served with divorce, that you understand, and the summons with the papers will tell you that you have 21 days to file an answer and counter petition with the court. So your first step once you receive that is make sure you know the timeline, and then you can start looking at your options. We always encourage you to, at that point, reach out to a divorce professional who can help you understand what's happening, what your options are, and how you're going to proceed in this action. If you have any questions about your particular case, if you've been served, give us a call or go to my website at jrlawgroup.com. As always, follow us on Instagram at JR Law Group, and thank you for watching Family Law Friday.